All right, well, thank you again for joining the American Red Cross IHL team for this very important talk about non-state armed groups and international humanitarian law. Our speaker today is Ezequiel Heffes, who is a senior policy and legal advisor at Geneva Call. Geneva Call is a humanitarian NGO that promotes respect of humanitarian norms by armed groups. Mr. Heffes holds an LLM in IHL and Human Rights from the Geneva Academy and a law degree from the University of Buenos Aires School of Law. Prior to joining Geneva Call, Ezequiel worked for the ICRC in Colombia, Afghanistan, and the Democratic Republic of Congo. He has widely published on different international law issues, including on child protection issues, and is the author of an upcoming book entitled Detention by Non-State Armed Groups Under International Law. So with that, I'll hand it over to our speaker, Mr. Ezequiel Heffes.
Thank you very much, Christian. Can you hear me well? Yes, thank you very much. And thanks to the American Red Cross for the invitation to speak today about the experiences of Geneva Call dealing with non-state armed groups or armed non-state actors. That's the way, the term that we use at Geneva Call, and how we work to engage with these entities to enhance or to increase the respect of international law in conflict settings. So what I'll do is, the idea that I had for today, since we have an hour, is I'm going to give you a brief introduction of what humanitarian challenges we see on the ground, as well as some of the elements that we use to engage armed groups on humanitarian norms. This is going to be probably 15-20 minutes, and then what I like about these sessions is that they are as interactive as possible. I know that the Prezi is not yet on screen, but I'll share it right now. Because I like these presentations, this type of introductions of the work of Geneva Call and the humanitarian challenges that we see to be as interactive as possible. After 15-20 minutes, I would really like to hear some questions, some thoughts, some reflections from the people who are actually listening and observing this presentation from various places, so we can discuss and we can reflect together on how humanitarian actors and how we can actually increase the respect of international law in armed conflict. So I'm going to be speaking about different things. The first thing that I'd like to share is I wanted to set the scene on what are the humanitarian challenges that we see on the ground. And I have identified 4, but of course there can be many more. But just the main 4 that we can quickly identify is that there is an increasing involvement of what we call armed groups in the world, actually, in the multiple armed conflicts that we see nowadays. All the studies that we can actually identify observe that the majority of armed conflicts nowadays are non-international armed conflicts. So this means conflicts between non-state armed groups and states, or between non-state armed groups themselves. Then, in addition to this, what we observe nowadays in the humanitarian realm is that there is actually a variety of armed groups with different structures. So what does it mean? Is some groups, for instance, have a kind of a vertical structure in which a hierarchy it is observed. Other groups have not so much a vertical structure, but they're more horizontal in nature. They have a different degrees of command and control. So in this horizontal structures, for instance, more power is assigned to the heads of the units and not so much to the heads of the leadership of the group. On the other hand, the groups that are more vertical structured, the distribution of power inside of the group is different. So this is actually a challenge because international humanitarian law or international law observes armed groups in a specific way, and sometimes it's not very easy to place these different structures or different organizations of the armed groups in this humanitarian law sphere. The third humanitarian challenge that we observe is, and we turn on the TV every day and we can see this, is that there is a lack of compliance with humanitarian norms. This is not an exclusive realm of non-state armed groups, but of every party to a conflict, but of course it includes non-state armed groups. And I wanted to focus here on something that I will come back later, is a lack of compliance with humanitarian norms. So not with IHL in general. And I'm gonna come back this later, because I want to reflect with you on actually when we actually think about compliance, it is better to think about compliance in terms of norms and not so much of legal regimes or like international law in general. And the last one that we observe is that there is a lack of knowledge and ownership of international law by armed groups. And I think this is key for any humanitarian organization dealing with non-state actors or non-state armed groups, because I'm a lawyer, I've studied international humanitarian law, and for us, there is kind of an issue in terms of organization of the group. So once the non-state armed groups, they reach a certain level of organization, and they reach a certain level of violence against the other party, then we say that international humanitarian law applies. But when we actually go and sit down with the groups, we observe that sometimes they have very little knowledge of what that means. You know, they simply don't know their international obligations. They don't know what they have to comply with. And when we think about this, in any given society, the circle of people who know about the law is very small. And when we think about the circle of people within those circles who knows about international law is even smaller, and who knows about international humanitarian law, even smaller. And the differences between humanitarian law, human rights law, international criminal law. So all these different branches that international law includes nowadays is very, very tiny. And there is this assumption that armed groups, they know about all these things, and it is often not the case. So this is also related to the challenges of compliance, the third point that we see. So the reason why armed groups actually breach their international obligations. So I have identified 4 here, again, based on our experience. The first one is related to this lack of capacity and knowledge to apply their international obligations. And I'm saying this because, for instance, I mean, I've been in various dialogues with non-state armed groups, and you know, when for instance we come and say, you know, you cannot use and recruit children below the age of 15 or below the age of 18, depending on the standard that we take. Sometimes they don't know this. They have no idea what's the minimum age according to international law. They don't know that use and recruitment of children below the age of 15 might be a war crime according to the Rome Statute, or they simply don't have the capacity to assess the age of individuals living in the territory they control. Again, international law would assume that that everyone has an ID and everyone knows when they were born, but suddenly in the territories controlled by armed groups, this is not always the case. People may not have IDs, and then for the party that is conducting the recruitment, it might be a challenge to differentiate between children and adults. The second reason on why parties may breach their international obligations is that they might have a different interpretation of the specific norms. So a clear example of this is the rule protecting civilians. So humanitarian law, the law of armed conflict, would say that parties should distinguish themselves from the civilian population. So, and of course, that deliberate attacks against civilian population is prohibited. But when you actually inquire, what does it mean to be a civilian, or to be a civilian who's participating in the conflict, or to be a member of the opposing party, then sometimes the interpretation of this specific term might differ according to the context. So for some people, for instance, there is sharing information with the enemy could amount to be direct participation in hostilities. For other parties, other groups, sharing, selling goods in the market to the opposing party could be assisting the other party in their military endeavors. So that could actually be direct participation hostilities. For international law, the definition might be different. So when we think about the reasons why there is a mismatch between the behavior of the group and what international law says, sometimes there is an issue of an interpretation of the rule. Of course, I'm not trying to be naive. The third reason that there might be on why parties to a conflict may breach their international obligations is the lack of willingness. And they might not be willing to respect, for instance, international humanitarian law at large, or they might say that they're not willing to respect international humanitarian law at large because this is a creation of states, and they have not participated in the signing or ratification of the Geneva Convention. So they don't agree with international humanitarian law. They could say that this is a Western imposition as well. Also, they could be against certain specific norms. So for instance, I was in touch with a group, and we were discussing about again, the prohibition of using and recruiting children below the age of 18. And Geneva Call, this is a standard that we push because we try to push for the most favorable treatment of children. And the feedback that I got from the commander of the group was, we are very much in favor of not attacking civilians, of not attacking healthcare facilities and healthcare staff and all of the rules of international humanitarian law and international law in general. But in this specific point, we don't agree with the minimum age of recruitment that you are saying that exists. Because for us in our community, when you are 12, 13, 14, you are an adult already. So our interpretation of that specific rule is different. We do not agree with what international law says, with that specific rule of international law. Again, this should be seen as different to a group that rejects international law as a construction, or that they see international law as an imposition from Western states. And the last point is when we think about the first 3 points, there is quite a rational aspect of these 3 points. So there might also be non-rational reasons why armed groups not respect international law or some of the rules. So for instance, and this is something that is very much underexplored when we think about, again, international law and whether it is respected or not, on what are the individual reasons, or how the individual experiences can affect the behavior of fighters on the ground. So for instance, if a children who has been an adult who actually was used and recruited, or was recruited when he was a child, whether this has an impact on the behavior, his or her behaviors when he or she is an adult. So this is very briefly the reasons why parties might breach their international obligations. There are some reasons why they might respect their international obligations, and I included a few. So the first one that I think it is key is related to the reputational aspect. So for certain groups, in the first 2 are actually relevant here. For certain groups, there is an issue of legitimacy. So they want to be perceived as respectful of international law. And this is why they might respect certain rules of international law. They might commit to respect to certain rules of international law through different means. And this could be before the international community or before local communities and local stakeholders. So an armed group may behave in a certain way because they want to gain acceptance by states or by international organizations. They might also respect certain rules because they might want to be well perceived by the local community. I always say, when you work for a humanitarian organization and you kind of visit the community where the armed group is, that group, they might want to be seen as respectful of the rules, both with respect to the humanitarian organization that is visiting, but also with respect to the local community that is around. Again, I'm not naive. I know that there are situations of violations, but I'm just trying to summarize some of these explanations and to put them as simple as possible. Then, as there might be different interpretations of the content of the rules of international law, there might be similar interpretations. So they might have, for instance, they might the local costumes might be aligned with international law. There might be some local rules prohibiting sexual violence, for instance, that are in line with international legal standards, and that might be a source of respect for these groups. Then there is an issue of reciprocity. And I included this because I was in touch with a couple of groups, and we had this discussion in terms of, I asked the question on how they would treat enemy wounded fighters when they detain them. Would they provide them with healthcare? Would they provide them with as soon as they need it or not? And I remember a couple of fighters once in a very informal discussion, they say that they would not treat them first, or even sometimes they would execute them because the other party was actually doing the same with respect to their comrades. So there is an issue of reciprocity here. On the other hand, I was in touch with actually a member of the group who had been detained by the other party and was released. And he said because that person was well treated by the other party, then he would well treat the enemy detainees that they would have. So it is very important on how parties actually may, if whether they respect international law or not, this might have an impact on what the other party is doing. And this is actually very, very important. The behaviors of any party to the conflict, they should not be seen in isolation. They are the result of interactions with international organizations, local communities, local religious leaders, for instance, what the other party is doing, what third states or third parties are doing. So it's a mix of interactions that shape how a party to a conflict, including an armed group, may behave. The other one is discipline, because again, this is related to the reputational aspect. Some groups may want to be perceived as a serious actor and not just as a non-organized entity that doesn't have any hierarchy or doesn't have any structure. So if there is a violation of international law, they would apply a disciplinary measure. They would try to kind of perhaps even prosecute or try that individual or apply a certain punishment. And the last one is, as there were non-rational elements for violations, there might be non-rational elements for respect, and the emotions of individuals here can play around and can be of use in this respect. If an individual had a positive experience, for instance, that might trigger a positive reaction as well. So just as a sort of a conclusion in this respect is that parties, from a rational perspective, parties actually weigh the cost and benefits of complying with international law, and the results will depend on the goals and the moment in which the behavior takes place. I'm going to give you a clear example of this. So I put here, this is random information, but let's assume that this is an armed group that existed between, let's say, 1990s and 2015. And I put here the reactions of groups with respect to two specific groups. So first of all, children who have been recruited and civilians. Let's assume that the civilians were deliberately killed. So what I put here is, I think there are two conclusions that are relevant in this chart. Again, this is random. It is not taken from any specific context. So the first one is that the respective party, the group, may change its behavior with respect to a specific norm during the conflict. So for instance, with respect to children, sometimes it may have a more active policy of using and recruiting children below a certain age. Sometimes it may not. And this might change for a variety of reasons. For instance, a group going through a peace process may decide to release the children that they have in the ranks and to stop using and recruiting children. This could be the same for other rules. Or for instance, it's not in a peace process, but it starts negotiating with another party, or the leadership might change, so they decide they might have a different attitude with respect to that specific group. The second conclusion is that parties to a conflict, including non-state armed groups, they have different attitudes with respect to different norms. So I come back to the point I mentioned before, but this is related to the responses that they may have. It is not the same to say non-state armed groups use and recruit children in hostilities, but that same non-state armed group may not torture detainees. Or the other way around, they might ill-treat detainees, but not use and recruit children below the age of a certain age. And I'm identifying this because when humanitarian actors, for instance, Geneva Call, when we engage with armed groups in specific thematic areas, we actually conduct the exercise of identifying which norm has been affected and why, and what are the possible elements that we can use to engage with that actor to prevent that violation to happen again. So this exercise of identifying which rules are being violated, it is essential. So this is why I think a norm approach is fundamental in terms of compliance when we reflect about compliance. So humanitarian engagement, and I'm conscious of the time, so I'm trying to go a bit quicker here, but of course, it's a sustained engagement. It's a sustained process that is usually conducted by humanitarian actors, but it can also be conducted by other relevant societal actors in countries affected by armed conflict and with the parties, but also involving other stakeholders. So for instance, there might be stakeholders that influence the behavior of non-state armed groups or states, and humanitarian actors may try to engage with those that influence the behavior of states or non-state actors, non-state armed groups, to change positively that behavior. So specifically with armed groups, the humanitarian engagement tries to promote compliance with international law, specifically with international humanitarian law, but it may also include other regimes such as human rights law. But it's also to preserve the humanitarian space. So for instance, in terms of access of humanitarian workers to the territories controlled by armed groups. And this is key in terms of security conditions. When you when you're trying to enter into a territory controlled by a non-state armed group, you need to actually talk to those people because they are kind of in charge of what's going on in that territory. So it is a pragmatic perspective on accessing the people living in those territories. And of course, in that regard, there is a key issue in terms of the provision of humanitarian assistance living in those territories. So if you want to distribute food or distribute seeds or distribute medicines in those territories, you need to talk to the non-state armed groups because they are controlling what's going on in that territory, and also for security reasons. So there are different entities doing these humanitarian engagements. I have identified a few. There is, of course, the ICRC is the leading organization in this regard, but then we have UN agencies. I'm going to give you an example afterwards. Then you have humanitarian and human rights NGOs, other entities. It might be third states, it might be even non-state armed groups, religious actors, religious leaders, communities, and community leaders may also engage with armed groups to promote respect of international law. And yes, this is a variety of actors actually undertaking this approach. So there are different methods, and it really depends on the organization or the actor that is undertaking this. It might differ according to the mandate. So humanitarian actors, for instance, some of them, humanitarian NGOs, they might not do naming and shaming. Human rights NGOs, they might do naming and shaming. Humanitarian organizations, they might do dissemination and trainings. Community leaders, they might do a dialogue. Third states, sometimes they might do capacity building. Some organizations or some actors, they do two or more of these various approaches. There are different tools of engagement. Again, unilateral armed groups can produce unilateral declaration, codes of conduct, special agreements, ceasefire agreements, and action plans that include humanitarian norms. And for instance, at Geneva Call, we might provide some input on these different tools. We have been consulted by non-state armed groups on whether some of the rules that were being included in certain unilateral declarations were aligned with international humanitarian law or not, and whether the language used was respectful of international law or not. Same with codes of conduct and with other agreements. And having said this, the legal basis for engaging armed groups, it is clearly established in international humanitarian law. We have Common Article 3 to the Geneva Conventions that specifically says that humanitarian bodies, such as the International Committee of the Red Cross, but of course not only, can offer their services to the parties to the conflict. And it's interesting because the need to engage armed groups has been recognized by numerous international organizations, including by the UN Secretary General. In its 2020 report on the protection of civilians, I invite you to take a look at this paragraph that I highlighted, because it specifically speaks about it says that, of course, engaging with armed groups does not confer legitimacy to such groups, but it specifically speaks about the need to engage armed groups by humanitarian and other relevant actors in order to enhance the respect of international law in conflict settings. And this has been recognized in numerous texts by the UN Secretary General, and this should not be seen in isolation. It's kind of a trend right now that on the importance of dealing with non-state armed groups on humanitarian norms to enhance the protection of individuals in conflict settings. So a couple of challenges related to these. Of course, there is a reluctance by the party to abide by international standards. As I said before, this could be due to different reasons. There is a lack of access, or due to insecurity, or it could be also restrictions imposed by certain states. Certain states might not be willing to accept humanitarian engagement with the non-state armed groups active in the territory, but it might also be that there are clashes, or that there are other situations of insecurity, and then the humanitarian actor cannot reach the commander of the group or cannot reach the camp of the group. So it's difficult to maintain this humanitarian dialogue. There are the counterterrorism legislations that have been adopted in different countries and by different organizations. Of course, criminalizing humanitarian engagement with armed groups has been a challenge for humanitarian actors. Hopefully this could be addressed, but it's still a challenge. There is a fragmentation within armed groups or their decentralized structures. And this is quite important because when you talk to an armed group, it's quite a challenge if the group does not have a stable structure. If the group is going to, for instance, split in a couple of weeks or a couple of months, then the dialogue that you've been building, you might have to start over again because the group split, or there is a new commander, or it's much more difficult to actually for the group to internalize the messages, the humanitarian messages that as a humanitarian organization you're sharing. And then, of course, there is a lack of capacity to implement some of the humanitarian commitments, and this is on the part of the groups. You know, you might have groups committing to respect to certain guarantees, and then because they don't have the technical capacity or the material capacity to do so, then it's very difficult. And of course, there's no assistance often in this regard. So, for instance, our groups, they actually they have to, if they detain individuals, they have to provide certain safeguards to those detainees, food, water, space, but they might not have the actually capacity to do so. So two quick experiences. The first one is Geneva Call. The second one is, which I'm going to go faster, is from the UN side. So Geneva Call is we're a humanitarian organization that promote respect of humanitarian norms by armed non-state actors, and this is how we call them, to include as many entities as possible. It was created in the 2000s, so it's interesting because in the 90s, there was a movement that led to the signing of the Ottawa Convention in 1997, a movement to ban anti-personnel mines. And a group of people from that movement felt like the whole landmines issue would not be solved unless armed groups would be also involved in these discussions. And they created Geneva Call specifically to work on the prohibition of anti-personnel mines. Since that time until now, we have expanded to other protection issues and IHL in general. And this is because in the first few years, Geneva Call was quite successful in sitting down with groups and convincing them not to use anti-personnel mines and destroying the stockpile of anti-personnel mines that they had. So suddenly key stakeholders were saying to Geneva Call, why don't you also deal with child protection issues? Since you're already sitting down with the groups, why don't you also deal with the prohibition of sexual violence and gender discrimination? And because of that, we have addressed numerous rules. We have engaged more than 150 groups so far, and on different thematic issues. So we have a sustained and constructive engagement with armed groups on humanitarian norms compliance. This is not a one-shot. It's a long-term engagement. It's a long-term dialogue with the groups. And we may have a direct and indirect engagement. This means that we might talk to the groups themselves. We might also talk to other entities that might influence the behaviors of the group. The branding tool of Geneva Call is what we call, what we have is a deed of commitment, which is, I'm going to explain a bit now, but is a unilateral declaration that armed groups can sign, and they commit to respect to certain international obligations. And then Geneva Call can monitor the respect of these obligations. So I have conducted several monitoring visits. So for instance, if they commit not to use and recruit children in hostilities, then we can go there and check whether children are in the camps, whether if they are used at checkpoints, whether they're they are with weapons, what's the situation of children. We will talk to the communities, we will talk to different stakeholders. And the dialogue that Geneva Call has is public and it's transparent. So of course, we might have some confidential dialogues with the groups, but if you go to the website of Geneva Call, then you're going to see all the groups that have been engaged with and which thematic area. This is public. And we believe that there's no armed groups that is out of reach. So we try to engage every armed group that exists, as long as, of course, it presents a humanitarian challenge. So the deed of commitment, as I said, is a standardized unilateral declaration. And it's interesting because it is signed at the Alabama room, where the first Geneva Convention in 1864 was adopted. So there is a kind of a powerful element there in which armed groups come to Geneva, they sign at the Alabama room with Geneva Call and a representative of the Canton of Geneva. The three entities sign this, and then we can go and monitor whether the obligations included therein are respected or not. We have 5 so far. One of them is what we have on children, on sexual violence and gender discrimination. We also have on landmines, on healthcare, and this year we're launching one on the prohibition of starvation and food-related problems, which also includes some elements on protection of environment that we have identified in our exchanges with the groups. Some general reflections: some groups can sign one or more deeds. It's interesting because we have had some experiences in which the signing of the deed triggered the state to ratify the treaty relevant to that subject. For instance, the Ottawa Convention, states ratifying the Ottawa Convention after the group had signed the deed of commitment with Geneva Call. So because of some sort of pressure that the other side was signing a tool in this field. And then all the deeds actually include a provision that I think is very interesting, because they ask the groups to promote also the deeds with respect to peers. And this is important because, for instance, in Geneva, we often organize meetings with armed groups. We bring armed groups from different places of the world to discuss about international legal issues, including on issues related to the deeds of commitment. So we conduct dissemination and trainings. Here is in South Sudan, in Syria. We use specific training materials such as booklets or videos. So main achievements: more than 65 groups have signed one or more deeds. We have had some good compliance. So for instance, children who have been released from the ranks of the groups, the stockpile of anti-personal mines by the groups destroyed, internal policies have been adopted and adapted. And for instance, or armed groups, they have, for instance, recently we had a group that was, its military base was next to a healthcare facility. So after engaging with Geneva Call and signing the deed, then the group moved its military facility away from this healthcare center, so it would not be put in danger from the attack. This was in the DRC, and it was quite recent. And there is an increased humanitarian assistance in the territories controlled by armed groups, because again, they are open to this humanitarian dialogue. So just to finalize, to show that there is also other mechanisms working on this, in addition to the ICRC that of course engages with all parties to a conflict. Then at the UN, there is a specific framework created on the protection of children, and they monitor the respect of various violations, these 6. And it's interesting because every year the UN Security Council, the UN Secretary General publishes a list of states and non-state actors that commit one or more of these violations against children. And then the UN actually can engage with these states and non-state actors to conclude what they call action plans. So to commit these groups to respect children's safeguards and to be delisted potentially from these elements. So just to show you that engaging armed groups and non-state armed groups on humanitarian norms is something that is not only an exclusive realm of Geneva Call, the ICRC, but also there are other organizations doing it for various purposes, such as access or child protection issues. Having said this, I think I would really like to hear your views on this or your questions. I would like to thank you very much. For more information on this, you can, of course, visit Geneva Call's website. Thank you very much. And I'm going to stop sharing.
Let me see. All right, well, thank you so much, Ezequiel. I know I learned a lot, and I continue to learn a lot from the work that Geneva Call is doing. I do have a couple of questions. A couple of them are going to be more policy and approach oriented, and then one is specifically going to kind of be more legal focused. But the first one I wanted to ask you was, and you touched on this a little bit, but I wanted to know, when non-state armed groups do sign on to these commitments, you know, part of the approach is to, during their course of their operations during the conflict, to protect people and to provide greater assurance that certain rules and obligations are understood and will be followed. But mine is more, have you seen from your work in the field or from your colleagues' work in the field that it also induces more state, the likelihood of a state approaching these groups and having more formal political negotiations or peace discussions as well, if they sign on to these?
It is something that it might be possible. It really depends on the context. I don't want to generalize this, but of course, there is an issue here in terms of the visibility of the engagements that the armed groups undertake. So when armed groups, they decide to sign a deed of commitment with Geneva Call, but other tools as well, they show to the public out there that they are, at least on paper, willing to commit to certain humanitarian norms. And of course, this can be an element that certain states, other armed groups, other humanitarian organizations, they may rely on when engaging with these armed groups as well. So this is indeed some of the tools that can be used. in terms of, for instance, peace negotiations, Geneva Call, we have been invited to certain peace negotiations by states when dealing with non-state armed groups to participate and to provide some input on the law applicable to non-state armed groups, but also in terms of, whether, specifically with respect to the how to include certain provisions in the agreements, how to discuss certain issues, or even by the armed groups themselves, that they were about to start peace negotiations with states, and they wanted to hear more about specific rules that they were not aware of. So, for instance, in terms of accountability, about the role of the ICC, about the role of transitional justice, about certain specific norms that they wanted to hear more about.
Yeah, sorry about that. So after they sign these declarations, say that they commit to the rules that you're proposing, and after the training, et cetera, my question is, to keep that from just being a formality and something that's on paper, what are the mechanisms in place from certain groups, or within these declarations, are there certain commitments that there will be follow-ups to make sure that these rules are being addressed on, obviously different than like a state obligation, but are there like any mechanisms that, there's, I want to say enforcement, but maybe a review of the actions to make sure that they're being followed? And if so, how do you see that being successful on,
Yes. Yes, there are a few tools that we can see. So specifically in the deeds of commitment, there is an obligation of the groups to internalize the obligations they are committed to. So for instance, if they decide, so they could adopt internal orders, they could include these topics in the training materials that they have, they could include these topics in the trainings that they conduct with their own members. They could include it as part of, if they, in this whole idea of internal codes of conduct, if they commit a violation of the rules, that there could be some punishments. So there is a whole internalization of this, and Geneva Call, we often help in this regard as well. So the obligations that the deed of commitment should not be seen as an isolated tool. So it is part of a long-term engagement that we have with the groups. It entails trainings beforehand, so they are aware of the obligations they are committing to respect to. It includes assistance afterwards, so they actually respect the obligations contained in the deeds. So it is, I would say, it's part of a package that Geneva Call has to increase the respect of humanitarian, of civilians and of humanitarian norms in complex settings.
Okay, excellent. So now I'm going to go to some questions that have been coming in, and then if there's time, I'll go back to my third question. But the first question asks whether, in your opinion, the work of humanitarian organizations, for example, Geneva Call and the ICRC, engaging with these groups can be seen as shaping IHL rules applicable to them. And then there's a follow-up to that. So following your first question, to what extent the deeds of commitment / unilateral declaration by armed non-state groups can be seen as lawmaking in terms of IHL of NIACs? So there's a couple of questions on that, law formation, and then also.
Yeah, I'm gonna start. The second one is I would say easier. So I mean, this is very legalistic discussion on lawmaking in terms of IHL. The classic perspective would say that it is states that and those that states grant this power that can create international law, such as the case of certain international organizations. So we don't observe these deeds of commitment as international lawmaking as such, but as I would say it's more in terms of committing the groups with those obligations that already exist out there. So we're not bringing new obligations to the table, but we are mirroring the obligations that exist at the international level, and armed groups are committing to respect to these obligations as a form of unilateral declarations. But they're different tools that armed groups can use. So not only deeds of commitment and unilateral declarations, they can sign agreements with states and non-state armed groups. So the Common Article 3 of the Geneva Conventions explicitly mentions the possibility that armed groups and parties to the conflict are encouraged to sign special agreements, for instance. So again, this should be, I think, differentiated with the formal IHL making that states or international organizations may do. With respect to the first question, I don't think we're actually shaping the IHL rules applicable to them. What we're trying to do is to explain them as I would say, as good as possible, as well as possible, so they understand what obligations they have. So if we say that they cannot, again, use and recruit children, so what does this mean, and what elements and tools they have to actually respect these obligations. So not in terms of affecting the rule as such, but to bring in the rule to the reality of the actor.
Right. And then one quick question that I think is important to know, because I know we have a lot of people here from a lot of different disciplines, is maybe you could just briefly explain the difference between international law versus international norm.
Yeah, so in the presentation, what I try to point out is that, when we speak, often discussions are related to compliance with international law. Some people say X or Y non-state armed group, they don't respect international law, they don't care about international humanitarian law, they reject international law. And what I try to say is that the scenario is more nuanced than this. So often what happens is that non-state armed groups or state parties, it's like whoever we assess the behaviors of, they might have some approaches with respect to certain norms and a different approach to other norms. They might, for instance, commit not to use and recruit children in hostilities below a certain age, but at the same time, they could ill-treat detainees, for instance. So they might be respectful of certain international norms, but disrespectful of other international norms. So what I'm saying is, in terms of compliance, saying they don't respect international law at large, I think we need to discuss more in detail what actually this means. And a norm-oriented approach would be, I think, a better solution when reflecting about compliance and solutions to increase the level of compliance for these norms.
All right, and then I have another question. Oops, 1 second. Sorry about this. So how powerful is the notion of reciprocity in discussions between Geneva Call and armed groups? Is there a strong notion in the context of humane treatment of prisoners of war, for example, that if armed groups respect the prisoners they detain, that their members are more likely to be protected when they are detained? So how important is reciprocity in the approach?
Well, of course, the thing is, you should be aware that in international humanitarian law, parties to a conflict, they have to respect their international obligations regardless of what the other side is doing. So this is something that we try to explain. Of course, when they raise the argument of reciprocity, as I mentioned before, this might be a bit more challenging, but we try to strengthen the point that they have to respect international law regardless of the other side is doing. And we might use different elements to do so. It really depends on the group. So for instance, for some groups, they don't want to be perceived as violators of international law by the international community. So for them, they don't want to disrespect the law as the other side is doing. So for us, again, is a message that reciprocity is not allowed in international humanitarian law. And if the other side is torturing or treating detainees, they shouldn't do this because of that.
Right.
They shouldn't do it at all, actually. But this is not an argument should hold.
Yep. And then another quick differentiation, or maybe something that you can expand on, is how is the work of Geneva Call different from the ICRC? And part of the question says, where does it overlap? But with that, I kind of think, is there coordination between the two, or are there similar approaches?
Yeah, there is. Obviously, there is a coordination. The first difference is that Geneva Call is a much smaller organization. So the ICRC, I think, has 20,000 staff working all around the world in many different conflict settings and other situations of violence. Geneva Call, we are probably 150 people around the world, so not so many. The other difference is that we engage exclusively our non-state actors. So the ICRC deals with states and non-state actors. We exclusively deal with our non-state actors. And I would say that there are two more differences. The first one is that our engagements are public. So as I said, you can go to the website of Geneva Call and you can see the groups that have been signing deeds of commitment with Geneva Call. And these deeds of commitment also allows us to publicize situations of compliance and non-compliance. So if we see a violation, we can publicize this. If we see a situation of respect, we can also publicize this. Well, the ICRC, I don't want to speak on behalf of the ICRC, but they work in a confidential way with the parties to the conflict, and the dialogues that they have, they're confidential in nature. And the last point is that Geneva Call, we don't provide any assistance. So it's not that we're going to distribute food or medicine, or we don't have healthcare. We don't have doctors or nurses. So we will, our basis, the basic work that we do is to engage directly with the armed actor to allow those specialized organizations to provide those services, but we wouldn't distribute seeds or food or medicine in the territories they control. We might talk to the group, so the group allow humanitarian organizations or other actors to do it, but we wouldn't do it ourselves because our mandate is different.
All right, thank you for that. And then another question, kind of to the approach of Geneva Call, because I know that's what you can speak to. But so when designing a strategy for negotiation or engagement with these groups, what are the important elements to take into consideration?
There are a few things. Of course, the first one, it is the level of organization of the group. So whether the engagement that we're going to have, we're going to be able to sustain that engagement in the long term. If we really want to achieve a behavioral change, having a dialogue with a group that is going to be disintegrated soon, or that it is going to be a split, or it's going to be fractured, or that is going to be much more difficult for the group to internalize the humanitarian messages that we share. Is much more difficult. So we try to assess whether the level of organization would allow us to have a long-term dialogue. And of course, the armed group needs to be a party to the conflict. It needs to have it needs to affect some of the thematic areas that we work on. So, for instance, the use of landmines, the protection of children, healthcare, cultural heritage, was displacement. Yes, so it needs to actually affect one of these rules. There might be other elements, but I'm just summarizing.
Yeah, of course. It's multifaceted and very complex.
We need to have access.
Because
we will need to have access for it.
Yeah, and in each group is different, and so I think that goes to another question that I saw in the chat, where it was saying that non-state armed group is just an alternative, maybe a more legalese word for terrorists, although like the actual definition of terrorist is debated, both in policy, but there are legal definitions to a certain amount. But there's this notion that these groups don't care about the law or respect it in general. So I guess this kind of the question was, why engage them at all? And maybe you can speak on the value that you have seen directly from engaging with these groups, and the ultimate purpose behind it isn't to legitimize, but ultimately to strengthen the rule of law within certain areas and to protect people. At least that's my interpretation of it.
Yeah, and I think that there is an issue of enhancing the respect of the law. And I think, again, we go back to this, how we should see the picture in terms of compliance. So the first is the difference, this whole idea of terrorist groups, and this is a very political term, of course. International humanitarian law, for instance, the Geneva Conventions, they speak about parties to a conflict, to conflicts of non-international character. The additional protocols speak about organized armed groups. Of course, there might be situations of attacks against the civilian population that might be considered as terrorist in nature. But what I'm trying to say is, there are a couple of things. So the first thing is this: we go back to this norm-oriented approach. Yes, some groups may violate certain rules, may respect other rules, may commit to respect to certain rules. So there might be some openings to discuss with these groups on specific humanitarian norms. The other is that if we go back to the chart that I shared, we saw that the armed groups may change their behavior during the conflict. So this if we actually reflect about this, it means that at some point in the conflict, the group might not be willing to discuss with humanitarian actors about certain rules. At another moment, they might be more open to discuss about this. So, for instance, and this is quite relevant because it could be during peace negotiations, or it could be because there was a change in the leadership, that they might be more willing, or the other way around, to discuss about these specific rules. So armed groups should be seen as evolving and dynamic actors, So this is why I think we shouldn't come up with these very strong statements like this group violate international law, and it's impossible to discuss with this group about anything that. So it's more nuanced than that. That's what I'm trying to say. Again, I'm not being naive here. There are violations of international law, of specific rules of violation of international law, that there might be situations of respect. Geneva Call, we have had some successful experiences dealing with armed groups on this.
Right. And then there was another interesting question, and I don't know how much you can speak on it, but I thought it was interesting because for those of us who work in this field and are familiar with certain things, now when it comes to tribunals or courts, there are certain instances where ICRC, for example, they might have a defense against like a subpoena to be a witness for a certain case because it could jeopardize their future work with certain groups and certain parties. And so the question kind of stems to that. Since the engagements from the Geneva Call are public, what is their relationship to tribunals? Have they been called for witnesses, or do you have, maybe you can't speak on like an internal policy against this, but at the same time, maybe you could touch on that.
No, we haven't. We have a very good dialogue with the different institutions. We haven't been called, yes, I mean, we haven't been called by any tribunal to actually disclose the dialogues that we have. But in any case, again, our engagements are public, and it's out there in the website which parties we engage and which thematic areas. Of course, it's different with the ICRC because there is a customary. It has been identified that there is a customary rule in terms of the ICRC, but with Geneva Call, as it is the case with other humanitarian organizations, I don't think we have any problem with. I mean, we haven't been called, and of course, we try to convey the message that we are a humanitarian organization, and our dialogues are humanitarian in nature. We're not a naming and shaming organization. I mean, the idea is based on this humanitarian dialogue, to enhance the respect of international law.
All right. Is there anything else that you wish to express? We did have one question about it was more how to get further involved in this work for people who are interested in it. But I think it's a question that might be best if you mind providing your email address. Would that be appropriate?
Yeah, of course.
In the chat.
Yes.
So I want to thank everyone for their time. Ezequiel, is there anything else you want to add?
No, actually, I wanted to thank everyone. I want to thank you and all the team at the American Red Cross. Of course, I'm happy to share these messages, to share our reflections on this. I think it is quite a relevant topic that it calls a lot of attention because of the reality we see nowadays, that it is with armed groups active in many different conflicts. So we're very happy to participate in these type of events. Thank you very much.
Yeah, thank you very much. And thank you to everyone. For those of you who are interested, a recording will be uploaded to rulesofwar.org/webinars. We have more events coming up, so please visit that address as well if you're interested in learning about those. Thank you to everyone who attended, and thank you again, Ezequiel, for sharing your knowledge and expertise with us on this very important topic. Please contact me at the email address that I just put in the chat if you have further questions. Us at the American Red Cross are always interested in discussing these topics with the general public. So if there's things you want to chat about, please let me know. And thank you again, Ezequiel.
Thank you very much. I also included my email in the chat box if anyone has any question.
All right. Well, thank you again. I'm going to stay on for a little bit so people can scroll through the chat and get those email addresses, and also see the Rules of War website that I listed, but a recording will be uploaded. Thank you again.